Good evening. It's about 6 o'clock and time to start the deep dive divorce webinar series. My name is Steven Leskin. I am a attorney in Portland, Oregon. I've been practicing here since 1992. And tonight we're going to be talking about the divorce trial. In a couple of other webinars, I've discussed an overview of divorce and I've talked about the things that have steps that have led up to trial. But this is going to be focused on a divorce trial itself, and we'll kind of I'm going to discuss like the moving pieces of the trial and what you have to know going into it, and what's going to be what the law is and what evidence is, and just kind of the format for trial. Tonight we're going to cover, well, talk about myself. I always do. I'm not going to do a deep dive into me. Nobody would be interested, and it only takes about 30 seconds. But we're going to start with what makes a divorce trial different from other trials. There are things about a divorce trial that are unique. I have tried criminal cases. I have tried civil cases. I have litigated administrative law cases like Social Security cases. And all of those cases are different from one another. But there are things that make divorce cases unique among them. And so we'll cover that just so that people can have some perspective. Uh, we'll talk about the anatomy of a divorce trial, what the various parts are, and then we'll talk about the law, evidence, and then I'll kind of sum up and wrap up um, tonight. So about me, this is where I talk about myself. So I was admitted to practice law in Oregon in 1992. I've been practicing family law since about 2001. I'm the founder of One Day Divorce Mediation, and so I still try cases, but my mediation practice is growing. And if you have questions about the mediation practice, you can find it at my website, Steven Leskin, or actually leskinlaw.com. And my contact information is at the bottom. When I do these deep dive um, webinars, my intention is to give people a really, really comprehensive view of the topic at hand. It's easy to find divorce information online. There's tons of blogs and um, just like the Oregon State Bar has, courses, not courses, but, information about divorce trials. You can find some information on the courts. This is intended to focus for, 45 minutes an hour on one subject. And so it really is a deep dive into a particular area of law related to divorce. And I hope that I'm putting forward information that people will find valuable. And with that information, they will find that they're able to navigate the system better, that they'll have less stress, that they can maybe streamline the process a little bit better. And so that's what the deep dive is about. Uh, During this webinar, I don't take questions. Uh, you can email me, you can call me. If you tell me you watched the webinar, or I will be happy to talk to you and go through any questions that you have. The questions, usually I find that like people ask too personal questions and they're not really helpful for the group as a whole, and they tend to be a little bit distracting. So if you can save your questions, give me a call, send me an email. I'd be happy, I'd be more than happy to go through it with you. Uh, you can also have some interplay with me online. These webinars are hosted through my Meetup page, which is Oregon One Day Divorce Mediation, on the website meetup.com. If you like the webinar, please feel free to go back. I would appreciate it actually if you just went back and gave me a good review, or just give me 5 stars or whatever it is. That really helps my rating. It helps others see that this is a valuable um, exercise for them. So with that, let's get into it. So first topic, what makes a divorce trial different from other trials? So one of the unique things about a divorce trial is that it's the only type of case where the most important part of the case, the element that you have to prove, is proved just by alleging it. So let me break that down a little bit. In any kind of case, there are elements that have to be proved. So, for example, in a divorce case, if custody is issue, you have to prove that it's in the best interest for mom, it's in the best interest of the children for mom to have custody or for dad to have custody. That's an element that has to be proved. Best interest of the child. In a criminal case, if, for example, you wanted to prove, like, if a defendant was charged with menacing, you would have to prove that the defendant intentionally intended to cause imminent fear of imminent bodily harm in the victim. So you have to prove the intention to cause imminent bodily harm. So all those are different elements. The fear of imminent bodily harm. Uh, so pointing a gun at somebody would be like, you know, intent to cause imminent bodily fear of imminent bodily harm. That would be menacing. So those are the elements that have to be proved. In uh, a divorce case, the crucial element that the court is going to grant the divorce on is that there are irreconcilable differences that have led to the irredeemable breakdown of the marriage. That language comes directly from Oregon law, and that language is found in Oregon Revised Statute, the ORS 107, and I forget exactly the site. I think it's 107005, like right in there. And that's language. But the unique thing about a criminal trial is that you don't have to prove that. The mere allegation that there are irreconcilable differences is enough for the court to grant the divorce. So this is a consequence of the state becoming no fault, right? We are a no fault state in Oregon, which means you don't have to prove fault. And if you think back to the old days, and we've talked about this a couple of times, where uh, marriage was considered like a type of contract. And in the old days, if you wanted to break the contract, you had to come back to court and prove fault. It's that was that same type of thinking, and has um, the courts matured and is thinking about the subject matter matured. People just said, why do you have to prove that? Why should the state make a judgment about whether or not you have proved fault? People are mature enough to know that they don't want, or self-interested enough, or it's just not the state's business to say you can't have a divorce. So that's not a element that has to be proved. If one of the spouses wanted spousal support, you'd have to prove the right to receive spousal support, and that right is in the statute. The elements that you have to prove before the court will grant spousal support is found in the statute. Irreconcilable differences, you don't have to prove that. It's enough to allege that there are irreconcilable differences. I kind of go on at length about this point because I just find it fascinating. Uh, and um, uh, and I will contrast this with something that comes up a fair amount in my practice. Um, Oftentimes, maybe once a month, I will get a call from somebody saying that they want to annul their marriage, that they want it to be as if the marriage never existed. And so the grounds for an annulment is that somebody didn't have the capacity or there was fraud. And so the my response is always to that that's a case that you could lose. You have to prove those elements, right? So if you wanted to take a case to annulment and say, well, there was no capacity, I didn't have the capacity to understand what I was doing, therefore the marriage, I'm not married. Uh, the other side could put on evidence that you knew what you were doing, and you could lose that case. So my strong uh, advice is always just plead it as a divorce. You cannot lose a divorce case. You will be done by the end of the trial, or just as a matter of course. You don't have to prove it. The other thing just to note on this topic, and I'll circle back to this a little bit later, is that if your divorce case is appealed, right, the one party appeals it to the appeals court, the divorce itself survives. The Court of Appeals will never, ever say, oh, somewhere there was a mistake and you are not divorced. So the fact of the divorce survives an appeal. Um, so once the judge signs the judgment, the divorce is final. And the only way you become undivorced is by remarrying again. Another aspect of divorce that's unique is that you don't have the right to a jury. I said at the outset that I also did have handled like Social Security Administration disability cases. So there's no right to a jury in those type of cases either. You only have the right to a jury in a civil or criminal matter. Uh, I've actually tried to research this before, why there are no juries in divorce cases, and I've gotten a couple of different responses, but I don't think I found the answer that I was looking for. I think that the reason that there's no jury has to do with child support. There's federal law that kind of harmonizes uh, child support throughout the country, and it unifies the way child support is collected. And that law, I think, mandated that there not be jury trials in divorce cases, and that actually makes sense. It's for a couple of reasons. One is that it standardizes awards so that two people in two different situations will come up with the same amount of child support, right? So because it's being decided by statute and by the judge, and you're just not going to get varying um, uh, um, outcomes. So uh, divorce trials never have jury trials. Uh, Different states may have fault where you still have to come into court and say, the spouse cheated on me or treated me so badly that I can't stay married, and that's fault. Uh, some of those states may still have jury trials, but I don't know that offhand. And so the third point I already covered, that the divorce becomes final once the judge signs the decree. I already covered that, but that's just the you are divorced once the divorce decree is final, and that the fact of the divorce in and of itself is not appealable. So those are some things that make a divorce trial different from other trials. All right, let's move on to the anatomy of a divorce trial. All right, so I'm not covering here things like pleadings, like the petition and the response, and the documents that get a trial moving forward or initiating the lawsuit. Um, I'm not covering discovery or uh, um, alternative disputes, the requirement to try to resolve your case before going trial. This right now, I'm picking up with essentially the day of trial. And so before the trial actually begins, the attorneys will file hearing memos with the court. And the hearing memo lays out the roadmap for the judge about what the two parties are going to present. And the hearing memo will lay out like what the law is, and what law the judge should apply to the case. It will lay out what the attorney thinks are going to be the factual points that are going to be proved during the trial. So the first thing that happens is that the usually the day before, the uh, attorneys will submit a hearing memo. Uh, it's very rare, but it does happen. Before a case actually gets going, there may be pre-trial motions. I did that a couple of years last year actually, and it was the first time that I actually had filed like a pretrial memo. But I thought if the point that was so crucial to our case, If we could work that out in a pretrial motion before the case actually got going, we would streamline the proceedings. So I filed my pretrial motion, and I did not prevail, but the intent was to kind of consolidate the case so that it would be easier and more efficient. So after and again, those are rarity in divorce cases. So the first thing that happens is the opening statements. The petitioner's attorney gets to, or the petitioner gets to stand up and say, "This is what my case is about. We're asking the court to award mom custody of the child, child support, and parenting time. We think that the equity in the house should be split like this. We think that the uh, debt should be split like this. We think that the retirement account should be split like this." So the opening statement lays out what the case is about. It's similar to the hearing memo, and a lot of times the attorneys just, "Judge, I know you I know you read my hearing memo. I don't need to make an opening statement." So hearing memo and opening statement usually is redundant. So the court, the attorneys just may not give an opening statement. Excuse me. After opening statements, the petitioner, the person who filed the petition, who got the case going, puts on his or her case first, and you do that by calling witnesses. So usually a lot of times the petitioner will be the first person to speak. We'll get up and say, we'll start answering questions from the attorney about any of the issues or of the case, like I keep coming back to, like custody, for example. So petitioner puts on his or her evidence first, and then is subject to cross-examination by the other attorney. And so let me first take the question of what is evidence, then I'll talk about what is cross-examination. Uh, the petitioner's case could involve the petitioner speaking to the judge or witnesses. And I'm going to come back to both these more in a bit, but you put on your evidence through witnesses. Even if it's documentary evidence, a witness has to testify that it is what it says it is, and it's not subject to a hearsay exception that will keep it out of. I said that backwards. Even if it's a document, it's going to be hearsay, but it will come into evidence through an exception. And so the witness comes in to validate, authenticate the written or audio or visual evidence, and that all comes in through witnesses. The witnesses could be um, uh, a party, it could be a third party neutral, or it could be an expert. And I'll talk about those more in a bit. Like I said, witnesses are subject to cross-exam, and cross-exam tests witnesses' knowledge about a subject or about an element of the case. After the and the right to I should also add, the right to cross-examine a witness is guaranteed by both the Oregon Constitution and the federal Constitution. After the petitioner has put on all of his or her evidence, the petitioner rests, and then the respondent gets to put on his witnesses and evidence and is subject to cross-examination. Once the respondent rests, the petitioner has the option to put a rebuttal case on. And the rebuttal case can only deal with evidence that's already in the record. And it can't introduce new topics, new elements, or new evidence. It can only rebut evidence that was put into the record by the respondent during the respondent's case. After the rebuttal, the parties make closing statements, and then the judge can either take the case under advisement or issue a decision right then and there. And if the decision is not given at the trial, usually will come in the form of a letter outlining what the judge is thinking and decisions, and that letter can take 2 weeks or a month. And then the last part is that the parties are instructed to draft the general judgment of dissolution, which is the divorce decree. And that judgment will reflect what the court ruled. If not, the parties hold something called a form of judgment hearing, and um, they go back and forth. When judge, you said this, and this is what we wrote, or the other side will come back and say, no, we think that the judgment should be this, or the one party puts something in the judgment that shouldn't be there and refuses to remove it. I've had that happen a couple of times, and so the judge will make a decision about the form of the judgment at a form of um, judgment hearing. After those kinks have been worked out, the judge will sign, if there are any kinks, the judge will sign the judgment dissolution. And with the judge's signatures, the parties are divorced. The judgment itself uh, goes into the judgment register, which is no longer a thing. It goes into, it is reduced to uh, a digital copy and stored online. There's no longer really a book of judgments. So let's talk about the law. So the first point to understand, and I've come back to this many, many times, is that the judge can only do what's authorized by the legislature as expressed in the Oregon Revised Statute. The judge derives his or her authority from the Oregon Revised Statutes, and if the judge exceeds their authority, the Court of Appeals will say, no, you don't have the authority to do that. Um, I've seen many times where a judge will order somebody like to move back in state, and the judge does not have that authority. The judge can say you get a house, or you got to pay a bill, or you get this much parenting time, but the judge does not have the authority to dictate where somebody will live. You can move and you can lose parenting time or something along those lines, but the judge does not have the authority to dictate where somebody will move. And that is usually in the form of like somebody wants to move out of state for a better job or to get away from an abusive spouse, and the judge will say, and they'll move and they'll say, no, you have to return. And I just personally don't think that the court has that. The court can fashion a remedy for that, but they don't have the jurisdiction to say, uh, the subject matter jurisdiction to say you have to return to the state or you can't leave the state. In Oregon, the law governing divorce is found at ORS Chapter 107. And if you want to look it up, it's easy to do. Just go to Google and type in Oregon ORS 107, and the laws concerning divorce will appear at 107. The laws governing spouse relationships is found at ORS 108. The laws governing children born out of wedlock is found at ORS Chapter 109. So custody cases where the parents aren't married are decided under ORS 109. And 109 pretty much adopts the provisions of 107 as it relates to kids. So that's where you find Oregon law. Oregon 109 also deals with things like third parties who may want custody of a child. Supposing there's like a deep relationship between the child and a third party or somebody who's not a parent, like maybe a step parent, and there's a divorce, that adult may petition the court under 109 for third party custody, oftentimes called grandparent custody. But it's not limited to grandparents. It could be any third party, and usually a lot of times it's somebody who's been a real and significant force in a child's life. And then so the divorce trial is going to be governed by ORS Chapter 107. That's what authorizes how the judge is going to divide up the assets, make provisions for the children, and award spousal support. And kind of surprisingly, it does not cover debt. The word debt is only mentioned once in ORS 107. Debt is actually found, and division of debt is actually found in Chapter 108. And it occurs to me as I'm just pontificating that uh, debt, marital debt would be an interesting topic for another webinar. So look for that. I've this I happen to know a lot about that, and I will do another webinar just on the provisions of marital debt. But debt is divided as part of the property. It's a liability, and it is divided in a just and proper in all the circumstances manner, which means that the court has discretion on how to divide debt, and they need to do it like in a manner that is just and proper in all the circumstances. And that's language that's found specifically uh, um, in ORS Chapter 107. Um, the specific chapter that the specific subsection that deals with dividing up the property and spousal support and attorney fees is ORS 107 105, and that's like I was just saying, that's the statute that authorizes and tells the court what its criteria is for division of debt and spousal support. ORS 107 137, for example, governs how custody cases are made and what criteria there are for deciding custody. And I just want to say that this is not the end of. There are many other statutes that deal with um, a divorce trial. There are statutes that deal with witnesses. There are statutes that deal with evidence. There are statutes that deal with the judgment. There are statutes that deal with the enforcement of the judgment. So this is just so this is the most this is I'm not going to say it's the tip of the iceberg because it's not that's not quite the metaphor, but this is what is the most important statute to know for the most important subject matter statute to know for a divorce trial. So the law we just have been talking about is law that's made by the legislature and found in the Oregon Revised Statutes. There's also a case law, and case law has been in the news a lot lately. Case law is also referred to as precedent. And um, the way the American legal system works in almost every state, I think there's one or two states that don't work this way, but the way states work is that the 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 courts work is that the legislature will pass a law, and then that law will come before a judge, and the judge will make a decision, and one of the parties will not like the decision, and then it goes up on appeal, and the appeals courts issue a written decision that on how the case should be decided. That decision is called case law. And so there are, for divorce laws, there's usually two or three cases that come out every week that deal with a different aspect of the statutes. And those are found in the advance sheets, and those modify how lawyers and people understand uh, the statutes. Uh, so I talked a little bit about the cases being the criteria for dividing property is just and proper. Well, what does that mean? It doesn't mean anything, right? Just and proper to me is going to be different from just and proper to you. And particularly if you're paying me as an attorney to advocate what just and proper should mean, you can bet that the person on the other side of the aisle is going to think that just and proper means something entirely different. So courts will issue decisions to interpret these kind of buzzwords. In Oregon, the case that uh, um, clarifies what just and proper means in terms of like uh, real property is called Kunze, Kunze, and um, it lays out an entire framework of what the parties have to look at to decide how property is divided. And Uh, and that's the case that's always cited, like in the hearing memos, like this under Coons. This is Coons, and this is what Coons says, and this is the result. So the appeals courts issue those written decisions interpreting the statutes, and those become case law, and they are they are called precedent. And the lower courts, the trial courts, are uh, uh, supposed to honor precedent. They're supposed to apply that precedent to a particular case. And the job of the attorney is just to say, well, this precedent applies or it doesn't apply, or to find more appropriate uh, um, precedent for your case, meaning, precedent that's going to move the court in your direction. And so um, precedent is very, very important to the judicial system. The understanding how precedent works is very important to the judicial system. Um, I a little reluctant to be political, but in the Dobbs case that came out last year, you will recall that there was a lot of talk about precedent, and that Roe v. Wade, had been uh, based on had become precedent for a number of numerous cases that came out of it, and that it was a so-called super precedent, uh, and not subject to be reversed, and it got reversed. So when a court reverses a decision, it's saying that that precedent is no longer valid or useful to the court or should be cited to the court for a particular position. And so once a court is supposed to rely on the cases that are decided, and in the same way that Roe v. Wade had been um, uh, relied on precedent going forward. Um, you don't reverse precedent lightly, because precedent is what gives certainty and predictability to the courts and to litigants. So in Oregon, just in Oregon, there are thousands of divorce cases. There are thousands of cases that um, interpret ORS 107 and all the substatutes in there. And so the first, like if you wanted to know like how the courts interpret the custody statute, you would look under cases for ORS 107 137, and you will see that those cases interpret uh, and direct how the trial court will interpret um, uh, that statute dealing with custody. Um, so it's not just enough to look at the statute and think that's the whole law. You also have to know the cases as well, and the cases used to be found in the law library. They used to, believe it or not, it seems like a distant memory now. You would go to the law library and you'd pull up books that would summarize cases, and you would like just look at the blurb and say, does this apply? Does this apply? Does this apply? And then you'd go and you'd pull the actual case and read the case. Or you would go and there would be lists of all the cases that dealt with a particular statute. And you go and you'd say, oh, this case, here's the site to that case, and go pull a book from yourself, and you say, oh, this is interesting or not, and then you leave it on the book on the law library table for somebody to clean up, for somebody else to clean up, because you just didn't do that. Now, uh, now, the law libraries are superfluous, unnecessary. So you pick your choice of which word fits better, because you can find all of the Oregon cases online. There's a website called Fastcase that's free. It's paid for by the state of Oregon, and that has all of the cases that are listed in it. And you just use the search terms that you need. You can start with, for example, if you're looking at a custody issue, you just put in the term, ORS 107, 137, and that will give you all the cases that have interpreted that statute. Or you could do a search like on uh, um, custody, best interest of a child, and you'll come up with other cases where those search terms are used. So that's how you find cases. The cases come out Monday, every Monday, yeah, every Monday morning. The Supreme Court cases and the appeals cases come out every Monday, and they're published in what used to be called an advance sheet, and you get copies of the advance sheets mailed to you. Now it's just online. You can just go click on the Supreme Court website and you can read the weekly advance sheets. So we talked about law made by the legislature. We talked about law made by judges and the appeals courts. And now we're going to talk about a third area of law that's also important to family law, and that's administrative law. Administrative law comes about as a result of the legislature delegating the authority to make law to the executive branch. Let me say that one more time. The legislature makes law. And there may be specific issues that they don't want to make law on. They want to delegate that. And so, since the executive branch of the government uh, enforces the law, it will delegate to the executive branch the right and give them the obligation to make um, administrative law. In family law cases, administrative law comes into play mostly in child support. There are administrative rules, Oregon administrative rules, that deal specifically with the calculation and enforcement of child support. Uh, you can actually see administrative law in action by going to the Oregon Department of Justice website. So Oregon Department of Justice, and then you'll see a section called child support, and that will have a child support calculator. And so all of that is administrative law. None of that is law made by the legislature. So it's the executive branch making law, and you're held to that the same way that you are held to the case law or to um, uh, um, legislature made law. So those are the three areas of law that you have to know, you have to be aware of in any divorce trial. I can't think of any other area of where, other than child support, where um, there's um, administrative law. Um, I can think of other areas where there's both other statutes or um, case law, but I think child support's the only area where administrative law comes into um, um, a divorce trial, and that's only where there's minor children. Okay, so we've been talking about law, did a deep dive on law. We talk about evidence. So evidence, um, evidence is any fact that's admitted into evidence. I misspoke. Any fact that's admitted into the record of the case. So evidence is subject to the Oregon rules of evidence. So, for example, if at trial the question is, did the father hit the child? I'm just making stuff up. And the witness says, I didn't see it, but I heard from the mother that the father hit the child. Well, that's hearsay, and so it's not going to come into the record. It's not going to be allowed to be admitted into the record. One of the attorneys will stand up and say, "I object. It's hearsay," and the judge will ponder it for a minute or two and say, "Yes, you're correct. It is hearsay, and so it's going to be excluded." So it's not evidence. It may be a fact, but it's not evidence. Evidence has a very specific meaning. It's facts that are admitted into the official record of the trial. Trial. Um, uh, the only evidence that a witness can testify is to something that they have personal knowledge of. So if you don't have personal knowledge, it's not going to be admitted into the record, right? So if you say, I read in the paper that the father hit the child, that's not evidence. The only evidence is something that you know through your own senses. So uh, that evidence may come in the form of somebody speaking. It could come in the form of a written document, but anything that is not admitted into the record is not evidence, and evidence is almost always just something you know from your personal experience, unless you're an expert. And I'll come back to that in just a second. So facts are admitted according to strict rules of evidence into the court's record, and the judge can make his or her decision only based on facts that are admitted into the record and are therefore evidence. An opinion is not a fact, right? You may have an opinion about whether or not it's a cold day. That's not a fact. You can say, in my opinion, and it still may be admissible for some reason or another, but opinions about like whether or not a doctor committed malpractice, that's not going to be admitted unless the person is qualified as an expert to give an opinion. So, continuing down that line, there are two types of evidence: spoken testimony of a spoken sworn testimony of a witness, and recorded facts, such as a photograph, a video, or a newspaper, or a report. Uh, Before any document is admitted into the record of the case, it has to be sworn to as a true and complete copy of the report that it purports to be. So it has to be, so if you're trying to have a photograph of a child admitted, it's got to be an accurate, true, and complete copy of the photograph. If it's an academic record, it has to be an authenticated copy of an academic record to prove that it is what it is purporting to be. It's confusing. It took me years to master this stuff. There are, in a divorce trial, there are three types of witnesses. There are fact witnesses who can testify about things that they know. There are know through their personal experience. There are expert witnesses who is qualified through their education and experience to offer an opinion. So if there's a financial expert testifying about how much dad could make if he had this education, that person would have to qualify that they have a background in vocational training, in economics, whatever it is to qualify that person as having expertise in this area such that they can offer an opinion, right? And they have to qualify, the judge actually has to qualify them as an expert before they can offer an opinion on a subject in the divorce. The third type of witness, and this is unique, is a child. A child under Oregon right by statute can be a witness in a case. And Oregon and what makes this unique to divorce law is that the child could speak directly to the judge in chambers outside of the presence of the attorneys, and whatever the child tells the judge does not come into the court record, right? The judge may offer a summary for the parties, but only the judge knows what the child told him or her, and so it's not subject to appeal, it's not subject to cross-examination, and so you don't really know. I've had cases where I did not get a result that I wanted based on something that the judge allegedly heard from a child, and I didn't believe it. I just did not. The case I'm thinking of, I did not believe that the court wanted to get to a result and used what the child said as a way to get to a result. So the way the child can speak to the court in one of three ways: either directly in chambers, off the record, through an attorney that's hired by one of the parties to represent the child, or the child can, if the child's old enough, the child can directly testify in court to what the child wants or thinks is in the child's own best interest. All right, we're at the end. That's what closing means. And so I've wanted to show like how the various pieces, the various moving parts of a trial come together. You've got the law, you've got the law that's going to be applied by the judge. You've got the fact witnesses who are testifying about things that they know. You've got documentary evidence that has to come in only under very strict guidelines. The documents have to be authenticated. They can't be hearsay. If they are hearsay, there has to be an exception to one of the hearsay rules for the documents to come in. Um, the attorney's role is to um, uh, guide this whole process along, and the judge's role is obviously to decide um, what the ultimate decisions in the case are. So, a divorce trial is a very complicated thing. It doesn't have, if people are doing it themselves, um, it's not going to be as complicated, but um, it is a complicated endeavor requiring a lot of knowledge to get to the court for the court to make the right decision. So I hope this has been informative to you. I hope to see you back in 2 weeks for the next divorce deep dive. Again, I am Steven Leskin. Um, Here's my contact information. I would be delighted to hear from you if you want to discuss any aspect of the seminar. And I think with that, we will close. So thank you for your attendance tonight.